Hello and welcome to another presentation by the Filmmakers Legal Clinic at Cardozo Law School. The Filmmakers Legal Clinic provides free legal advice to filmmakers seeking to move the social justice needle. We also provide training and educational programming to our industry partners. Today's presentation is on defamation, specifically as it relates to editorial choices by filmmakers. We will talk about what defamation is, why defamation is something filmmakers should be thinking about during all stages of production, and then we will look into a few case studies to better understand what can get a filmmaker in trouble. And finally, we will discuss some pointers and practical guidance in how to avoid being sued for defamation. So, first of all, what even is defamation? For that, let's bring in the First Amendment, which protects the freedom of speech and includes the right to express opinions and ideas. As such, it allows a filmmaker to tell controversial and challenging stories without fear of government censorship. This protection is especially significant for documentaries and investigative filmmaking. However, filmmakers can still face legal liability if their work incites violence, invades someone's privacy, or presents false statements that defame another person. Now, defamation is the act of damaging a person or entity's reputation by publicly making false statements. In the context of filmmaking, a person who feels harmed by defamatory content in a film, whether by direct statements or implied through editorial choices, may bring a defamation claim against the filmmakers or the production. Even small editorial choices, such as a caption or a voiceover, can potentially create liability if they convey a false and damaging impression of someone. Fortunately, there are certain defenses to defamation, such as truth, that is, that the statement is factually true and so cannot be defamatory, or that the statement falls under one of the categories of privileged speech. Ultimately, it is the filmmaker's responsibility to supervise risks of defamation in the various stages of production. So, how does one sue for defamation? Well, although defamation laws vary by jurisdiction, most claims require several key elements. First, there must be a false statement of fact. Statements that are clearly opinions or exaggerations are generally not defamatory. Second, the statement must be published, meaning a third party saw or heard it. Films, television programs, and online distribution easily meet this requirement. Third, the statement must identify the person involved, either directly or in a way that makes them recognizable. Fourth, the statement must harm the person's reputation. And finally, the plaintiff must show some level of fault, which depends on whether the person is a public figure or a private individual. As mentioned before, one important defense in defamation is privileged speech. These include statements of pure opinion, of public issues, and of public figures. Statements of pure opinion are generally protected by free speech, but are sometimes tricky to distinguish. For example, saying that a restaurant had poor service or an unprofessional atmosphere would usually be considered an opinion. However, problems arise when an opinion contains factual claims. For example, saying, "I think the service was bad," is an opinion. But saying, "In my opinion, the restaurant uses contaminated tools," introduces a factual claim that could be proven true or false. Even if someone says, "in my opinion," the statement may still be defamatory if it implies specific misconduct presented as fact. Speech about matters of public concern, such as politics or public policy, also receives strong protection. This is based on the principle that debate on public issues should be uninhibited, robust, and wide open. The public issue can range anywhere from nationwide constitutional book bans to local designation of a bike lane on a busy commuter road. Defamation in relation to such statements usually face a higher burden of proof. This is particularly relevant for documentary filmmakers, since many documentaries address political, social, or public policy issues. Courts also distinguish between public figures and private individuals. Public figures, such as politicians, celebrities, or prominent activists, must prove a higher level of fault in defamation cases. They must show actual malice. This means the speaker knew the statement was false or acted with reckless disregard for the truth. Private individuals generally only need to show negligence, meaning the speaker failed to exercise reasonable care. For example, if a journalist publishes a story claiming the mayor approved the bike lane on a busy commuter road because he secretly profited from the contractor hired to build it, the mayor, as a public figure, would have to prove the journalist either knew the corruption claim was false or recklessly ignored evidence showing that it was untrue, while the contractor, a private figure, would only need to show the journalist failed to reasonably fact-check before publishing. For filmmakers, this means portraying a private individual carries greater legal risk than portraying a public figure. But what is a public figure? Some public figures are obvious: politicians, celebrities, or well-known activists. But the line is not always so clear. For example, what about the spouse of a political candidate who appears at campaign events? Or social media influencers? Or individuals who become advocates after a major event? Courts sometimes describe these individuals as limited-purpose public figures. These are people who have stepped into the public debate on a specific issue. As such, for the purpose of defamation, they are only considered public figures for that specific issue. For example, in the middle frame, we have one of the parents of a victim from the Sandy Hook shooting, who has become an activist and nationwide voice for gun control. As such, he may be considered a limited-purpose public figure for this purpose only. So, if a filmmaker falsely claims that the parent fabricated statistics during a gun control campaign, the activist will likely need to prove actual malice. However, if the filmmaker falsely accuses the parent of having an extramarital affair unrelated to advocacy, the activist would then be treated as a private figure for that issue and only need to prove negligence. For filmmakers, this distinction matters because it changes how difficult it would be for someone portrayed in the film to win a defamation claim. Now, let's move on to defamation as related to filmmaking. Filmmakers make creative choices throughout production which shape and fit into the narrative desired by the filmmaker. Such choices include decisions about whose perspective to present, which voices to include, and which events to highlight. Cinematography can be used to influence audience perception by the use of suggestive framing, lighting, and angles. In post-production, selective editing, juxtaposition, and omissions can bend the truth, while music and voiceovers can make neutral moments feel ominous or emotional. For filmmakers, these techniques are essential storytelling tools, but they can also influence how viewers interpret a person's behavior or character. So, when do these storytelling tools become risky? Well, it's when they are used to create a false or misleading impression about a real person. This includes storylines that focus only on one point of view while excluding others that may go against the narrative of the filmmaker, or reenactments that present speculative events as if they were factual. It includes when lighting and camera angles are used to make a subject appear sympathetic or suspicious, or when camera framing cuts out the context of a wider picture. In post-production, reaction shots out of context can make someone appear evasive or guilty. Selective interviews may suggest that a particular viewpoint is universally accepted. And let's not forget about music, which can change the audience's perception of the subject. The legal question often becomes whether the film communicates something factually misleading about a real person, even if it never explicitly states it. Let's turn to look at some case studies. In the documentary Under the Gun, journalist Katie Couric asked members of a gun rights group how, without background checks, one could prevent felons or terrorists from purchasing guns. In the final film, the interviewees appear silent for several seconds before responding. However, the original footage showed that they actually answered immediately. The filmmakers inserted unrelated B-roll footage to create the pause. The group sued, arguing that the editing falsely suggested that they were unable to respond, that the added silence made them appear speechless. This particular case shows how even a few seconds of editing can dramatically change audience perception and potentially create legal consequences. Another example involves a clip of Donald Trump's January 6 speech in a BBC documentary. The documentary combined two separate parts of Donald Trump's speech that were originally about 15 minutes apart, making them appear to be one continuous statement. Trump argued that this editing misrepresented his remarks. The BBC responded that the edit was simply meant to shorten a long speech. For filmmakers, this illustrates how editing decisions, especially when combining different moments, can raise questions about whether the final portrayal is misleading. As another example, after the release of Making a Murderer, a sheriff's deputy sued Netflix and the filmmakers. He argued that the documentary selectively edited his testimony to make it appear that he planted evidence. The filmmakers responded that documentaries inevitably involve selective storytelling, and that it was impossible to include every detail from the trial. A key issue was whether viewers would interpret the series as advocacy and opinion, which would fall under privileged speech, or literal statements of fact. In 2019, a short video circulated online showing a student, Nicholas Sandman, standing face-to-face with Native American activist Nathan Phillips at a March for Life rally in Washington, D.C. Early news coverage, including the New York Times, portrayed Sandman as harassing Phillips, based solely on the video circulated. Later, longer footage revealed additional context involving other groups at the event. Sandman sued several news outlets, arguing that the coverage created a misleading impression that he engaged in racist conduct. This case illustrates how framing, editing, and incomplete context can influence public perception. It also serves as a cautionary tale to verify facts before publishing the content. With that, let's move on to some practical guidance. In theory, there are many parties involved in publishing a film that could face liability. This includes producers and writers, editors, distributors, networks, and platforms. In practice, lawsuits usually focus on producers or distributors, since they have the most control over the final content and the financial resources to pay damages. For filmmakers, this means production companies are often the primary legal target. If defamation is proven, courts may award compensatory damages, that is, monetary damages, for reputational harm or emotional distress. In more serious cases, courts may award punitive damages, especially if actual malice is proven. Filmmakers may also issue retractions or corrections, which can sometimes reduce damages. While injunctions are available, courts rarely block the release of a film entirely, because doing so raises significant First Amendment concerns. Even before a case is resolved, a defamation lawsuit can create major challenges. Legal costs can be substantial. Distributors or streaming platforms may delay releasing the film until the legal risk is resolved. A lawsuit can also damage the reputation of the film and that of its creators. In turn, even if the case is eventually dismissed, the financial and reputational costs of litigation can be significant. Filmmakers can reduce risk by focusing on accuracy, context, and transparency. This includes fact-checking statements and verifying key claims. If reenactments are used, filmmakers should clearly signal that they are dramatizations. Maintaining context is also important, so viewers are not misled by selective editing. Obtaining signed releases from participants can provide additional legal protection. These practices help filmmakers balance creative storytelling with legal responsibility and avoid defamation. And that's a wrap on defamation. Thank you for watching, and please check out our other presentations and tutorials for filmmakers. If you feel like you have questions or concerns about any of these issues, please feel free to contact us, apply to be a client, or visit our website. Also, follow us on social media and LinkedIn, where we regularly post updates on the clinic and the film industry. This has been a presentation by the Filmmakers Legal Clinic, housed at Cardozo School of Law's Center for Visual Advocacy, sitting at the intersection of film, law, and social justice. The Filmmakers Legal Clinic provides free transactional intellectual property and First Amendment legal services to independent filmmakers whose work encourages and accelerates social justice.